All rise. The Court of Appeal in for the 5th District of the State of Florida is now in session. The Honorable Richard B. Warfinger, Judge, presiding. All persons having business before the court draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning and welcome. Excuse me. Welcome to an oral argument session of the 5th District Court of Appeal. As the Marshal indicated, I'm Judge Orfinger, and I'm joined on the panel today by Judge Wendy Berger on my right and Judge Rand Wallace on my left. We have 3 cases today. 2 cases have been resolved already, so if you're here for Highsmith versus Cesare or Lopez versus Lopez, those cases have been resolved without oral argument. All cases will have 20 minutes per side to argue. The appellant can reserve as much time as he or she chooses. Just let me know. The clock's set at 5 minutes, but if you want something different, let me know and I'll be happy to adjust it. When it flashes orange, you're into your rebuttal time, and when it flashes red, it's time to stop. If you have a cell phone or computer with you, please silence it so that we don't interrupt the parties during their argument. And with that, as soon as I get myself organized here, we'll call the first case, which is JUDE LAHENS versus State of Florida. Give me just 1 minute here to get myself organized. Morning, counsel. How much time would you like me to reserve for you?
Good morning, Your Honor. 5 minutes, if you please.
Okay. You may proceed.
Thank you, Your Honor. Your Honors, my name is Gary Schwartz. It's my pleasure to represent Mr. Lahens in today's appeal. As previously indicated, I'd like to reserve the 5-minute rebuttal time. Pursuant to my briefs, I've set forth 2 issues that I'm asking the court to consider in this case. I'd like to start with the second, which deals with the question of ineffectiveness of counsel in failing to introduce Mr. Lahens' stand-your-ground testimony at his trial. This court's previously addressed the question of whether the stand-your-ground testimony fell under hearsay exception 90.80322, availability of declarant immaterial former testimony, in the case of Lahens versus State 204 South 3rd 982 from 2016. At that time, this court made the determination that, in fact, the stand-your-ground testimony of Mr. Lahens at his hearing was admissible pursuant to that hearsay exception. So, pursuant to this court's reversal of the summary denial at the trial level, this case was kicked back for an evidentiary hearing, at which time there was testimony regarding the decision whether to include or not to include the stand-your-ground testimony by trial counsel in Mr. Lahens' defense.
Mr. Schwartz, good morning.
Good morning, Your Honor.
As far as the testimony, there was in trial, wasn't there evidence presented concerning the interview of your client with law enforcement?
There was. That's correct, Your Honor. There was testimony. I believe that there was discussion of the initial statement my client, Mr. Lahens, made to law enforcement. However, that was it with regards, to the best of my recollection, with regards to my client's previous statements.
And then in the hearing, the stand-your-ground hearing, there was extensive testimony given by your client, and that included both direct examination and cross-examination, correct?
That's correct. The state did have an opportunity to cross-examine Mr. Lahens at the stand-your-ground hearing, and that was conceded by trial counsel on page 67 of the record.
And was there were inconsistencies between the two? And those were brought out during the stand-your-ground hearing, is that correct?
There were, although the state in its answer brief raises one inconsistency. Our position is that the inconsistencies were inconsequential or certainly not not substantial enough to justify a decision not to introduce the testimony.
Wasn't the inconsistency that in one aspect, he claimed that it was an accident, and then for striking the victim in the case, and in the other instance that the victim was attacking him, and therefore he struck him during the attack? I mean, that seems pretty significant.
That would be, Judge. However, I think on review of the record, you'll find that there was no testimony that it was accidental. Basically, there was testimony and there was a statement that that was Mr. Dorley, was the person who actually was struck by Mr. Lahens in Mr. Lahens' attempt to get past him in order to defend his brother, who was being held at gunpoint by Mr. Rodriguez. Mr. Lahens had, in his initial statement to law enforcement, characterized Mr. Dorley as a good Samaritan. And Mr. Lahens does never retracted from that position, really. He understands that Mr. Dorley was interceding because he saw Mr. Lahens approaching with a firearm. However, it was his position consistently that he struck him to get past him. That basically, while there was testimony that Mr. Dorley was aggressive with him in restraining him, but I think that the takeaway from every statement by Mr. Lahens was that basically the force was used to get past him in order to get to Mr. Rodriguez in defense of his brother, Mr. Berlin Lahens.
How do you demonstrate prejudice when substantially the same information came before the jury in the statement that was introduced by the police, statement to the police?
Well, the statement that Mr. Lahens gave to the police was somewhat abbreviated and didn't set forth all the details that was set forth in the stand your ground statement. And it's our position that it's sort of dangerous to state that it's duplicative for a defendant to testify, or basically in this case have his testimony admitted in the case of a stand your ground or a justifiable use of deadly force, in that the burden is on him. It's an affirmative defense. And no one, while there was an argument by the state, both at the trial court level and in the state's answer brief, that there was some witness testimony presented by trial counsel in this case, to wit, the testimony of Mr. Berlin Lahens, that really Mr. Berlin Lahens wasn't privy to all of the external stimuli that contributed to Mr. Lahens' reasonable belief that he needed to intercede utilizing deadly force in order to stop what he perceived to be imminent deadly force against his brother in this case. So,
Well, but doesn't that make us assume that there's prejudice? And I'm trying to understand how we objectively find prejudice. I mean, let's assume that you get over the first hurdle and that it was deficient performance not to introduce the statement. But now we focus on the prejudice, which is really where my focus is.
yes, sir.
Are you asking us essentially to assume that there's prejudice? And if so, what's the basis for doing that?
Well, as Your Honors have previously stated, there was extensive testimony set forth at the stand your ground hearing detailing the facts in which, from the beginning of that evening, the set of events, the course of events broke out, detailing most particularly the altercation with Mr. Dorley, which was not testified to in any detail by Mr. Berlin Lahens or really referenced in any detailed manner by Mr. Jude Lahens himself, his initial statement to law enforcement. And that was crucial for the jury to hear in order to understand that really he was not a true aggressor in this case, but was only reacting to the threat of immediate force. And without either Mr. Lahens taking the stand in his own defense, and there was testimony at the evidentiary hearing that he wished to do so, and if he were not able to do so, that he would like the stand your ground testimony presented to the jury. The jury was basically put in a position where they were not privy to all of the information that would have allowed a finding that Mr. Lahens was justified in his use of deadly force. Again, because of the fact that of the amount of detail that was missing in between, if the only thing they were provided was his initial statement to law enforcement.
Didn't trial counsel testify at the hearing that he attempted to get the prior testimony in, but the judge wouldn't allow it?
He did testify to that. That is correct. It's our position, and that was actually one of the reasons that the lower court made its finding in its order denying the motion for post-conviction relief. It's our position, I understand that that is a fact finding made by the trial court and entitled to deference. However, there is an abuse of discretion standard, and it's our position that there needs to be some competent substantial evidence in order to justify a finding by trial court, a factual finding, even keeping in mind that deference that is due to be accorded the trial court. Here, nowhere in the record is there any evidence that such a request was made. And that brings up my next point with regards to this issue, that as there was no testimony that trial counsel made a strategic decision not to attempt to introduce it, the fact that it was never attempted to be introduced is entitled to no deference as a strategic determination, because he never stated that he made a strategic determination not to introduce that testimony. If there are any...
That would be your reason why there was no appeal taken on that issue, was it wasn't perfected down in the trial court, is that correct?
Correct. He never, it's our position that it was never requested, and that position is backed up by its absence in the transcript of the trial. Now, that was brought up at the trial level. The trial judge had asked me, well, Mr. Schwartz, would you please indicate to me where trial counsel failed to ask for this transcript? And that becomes problematic. I said, Judge, if you look at any individual portion of the trial, at every one of those portions, you'll find that that request was never made.
And I know counsel mentioned that it was his recollection was that it was at a sidebar conference. Were other sidebar conferences recorded during the trial?
It's my understanding, Judge, and my recollection based on my review of the transcript, that they were. So,
Didn't the judge also make a finding based on counsel's testimony that there was a strategic reason not to introduce the statement?
he found, yes, he found that there would have been strategic reasons not to attempt to introduce the stand your ground testimony because it would have been duplicative and or it could have been hurtful because of the inconsistencies that we've previously been discussing.
Isn't it inconsistent on the one hand for counsel to say, I tried to introduce it, but there was a strategic reason not to introduce it?
Well, and you'll see in the transcript, Your Honors, that basically his position consistently was, I did try to introduce it. He actually stated that he made the strategic decision, this is almost a direct quote, to attempt to introduce the prior testimony so that Mr. Lahens didn't have to testify and to bolster his previous statements to the police. And he did acknowledge that at trial, the burden of proving up a justifiable use of force defense rested on the defendant. So that's why our position is that he didn't introduce it. There was never a strategic decision not to introduce it. He actually also stated erroneously that his belief had been at the time of trial that in order to lay the foundation for the admission of former testimony under 980322, Mr. Lahens would have had to testify. So he was incorrect in that. So if there's no further questions, I'd like to move on to the other issue.
Go ahead.
Thank you. Judge, and then the other issue is the question of failing to object or actually affirmatively agree to the instruction used with regards to the justifiable use of deadly force, both as it pertains to the aggravated battery of Mr. Dorley and the attempted murder of Mr. Rodriguez. There's a couple cases that I cited to in my brief, I believe they're Basalo and Brown, which deal with the inclusion of language in a self-defense jury instruction of the term injury where there was no injury.
There's sufficient evidence for the jury to have concluded that the victim of the aggravated battery was injured. I mean, there was evidence that he was bleeding, he was struck in the face.
That's correct, Your Honor. And our position would be that this problematic instruction could have been alleviated by simply including two separate justifiable use of force instructions, one as pertained to Mr. Doralee and the aggravated battery, where there's no debate that Mr. Lahens struck Mr. Doralee, and then the other being as it pertained to the justifiable use of force in defense of Berlin Lahens as it pertained to Mr. Rodriguez, where there was no striking or battery, but there was a deadly weapon. Now, at the trial level, when queried about why trial counsel had in fact agreed to the instruction in this case, he really didn't give any strategic explanation. He basically said, well, it was an amalgamation. There's no support that by an amalgamation, by simply combining the two instructions with regards to the two counts, does anything to ameliorate the taint of including the issue of injury with regards to Mr. Rodriguez, and in fact, it just complicates the jury instruction as it pertains to Mr. Doralee, because there's reference to a deadly weapon, which there's no allegation that Mr. Doralee ever carried. So basically what we're doing is we're making it harder and imposing an additional requirement upon Mr. Lahens in establishing an affirmative defense, which is fundamental error under the rationale of Basallo and Brown. Now, the state brought up the fact that those cases were decided subsequently to Mr. Lahens' trial, which is correct, but the fact is that those decisions are simply announcing law that had always existed. And the case law, the line of case law that stands for the same proposition is discussed in the Davis case, which is a 4th DCA case, cited at 804 South 2nd 400 from 2001, including the language, and in that case they basically talk about the difficulty and the problematic inclusion of terms like and or in jury instructions, which is exactly the problematic terminology that was utilized in this amalgamation. And there's an abundance of case law standing for the proposition that it's fundamental error to give an inaccurate and misleading instruction, or the effect of that instruction is to negate the defendant's only defense, which is exactly what happened by use of this amalgamated self-defense instruction with regards to both the charges against Mr. Lahens. I see that my time is up, so if there's no further questions from the court, I'll stand down.
All right. Thank you. Good morning.
May it please the court, my name is Deborah Chance on behalf of the state. It is the state's position that the trial court properly denied the post-conviction motion after an evidentiary hearing. The defendant failed to meet his burden in demonstrating that failure to object to the jury instruction was ineffective assistance. The defendant failed to meet his burden in demonstrating that not admitting the stand your ground testimony was ineffective assistance. The state submits no prejudice has been shown.
Do you think it was deficient performance not to introduce the stand your ground testimony?
No, I don't think so. At the evidentiary hearing, the counsel testified, well, to address my opponent's statements, his memory was a little foggy. This was about 7 years after the fact. He seemed to remember they had possibly discussed it at a bench conference. Maybe they discussed it earlier. He noted that the judge liked to handle things well ahead of time, so it's unclear where in the record this would be. But regardless of that fact, he didn't really...
You concede that there's nothing in the record that you could find that he tried to introduce this prior statement.
Right. This record on appeal in the trial transcript, I could not find anything. But he also indicated that he didn't really want this testimony in. There was inconsistencies between the defendant's own statement to police and his stand your ground testimony. There was inconsistencies between the brother's testimony at trial and the defendant's stand your ground testimony.
Doesn't it seem a bit inconsistent to, on the one hand, say, I tried to get it in, but there was a strategic reason not to get it in? I mean, aren't those two things inconsistent with one another?
I think maybe at first blush, but once we get into the development of the facts, he indicated at least that he initially sought to have it entered, but maybe on second thought he decided it wasn't such a good idea. The defendant's original statement to police, well, we don't have the statement to police in the record on appeal, but what we can gather from the record is that in his statement to police, he characterized Sonny Doralee as a good Samaritan. he merely hit him as part of an accident. There was some kind of characterization as to that. If he was then to go admit the stand your ground testimony, at the stand your ground hearing, the defendant characterized him as an aggressor. He was being attacked by Sonny Dorley. Those two defenses are inconsistent. Furthermore, the brothers' testimony at trial, well, both their testimony at trial and the defendant's stand your ground testimony differed as to when the two men left the club, the nature of the fight between the two parties. I believe the defendant characterized it as he was fighting off 3 people at once. The brothers' testimony was that there was no punches being thrown. And then they also differed as to whether Rodriguez threatened to shoot the brother while he held a gun to his head. Making the strategic decision to keep as much credibility with the jury as possible is a reasonable strategic decision, and I don't think that there is any deficient performance proven in that respect. I also don't think there's any prejudice as well. The defendant was still well able to present his defense rather than this being a case where there was just the defendant's own self-serving testimony that could have provided his self-defense. He had the testimony of his brother, the brother's girlfriend, and the counsel was still well able to argue to the jury that Mr. Dorley was hit as part of an accident. It wasn't intentional. He was merely protecting his brother. So I don't think either prong has been met here. In regards to the jury instruction, first I would disagree. Well, to my first point, the cases largely relied on the appellant Brown and Basallo. Didn't even exist at the time of this charge conference. He could have done all the research he wanted. He never would have found these cases, providing him with a basis to object to the instructions. And counsel cannot be ineffective for failing to anticipate a change in the law. If we were to look at it through that lens, I think we'd be applying the distorting effects of hindsight. And I think essentially there was no deficient performance here, no prejudice. If your honors have no further questions, I'll rely on the arguments in my brief and ask that you affirm.
Thank you, counsel.
May it please the court? Counsel? Thank you for your attention, your honors. A couple points with regards to rebuttal I'd like to make. Number one is, at no point did trial counsel state that he had sort of rethought his decision to include the ground testimony. Again, so I'll fall back on my original point, which is that there was no strategic decision testified to by trial counsel stating that I made the decision not to include the testimony. As such, the fact that he did not try to include is entitled to no deference as a strategy call. With regards to prejudice, the standard would be reasonable probability, your honors. So the question becomes, utilizing, had the jury heard all of the detail that was given by Mr. Lahens in his testimony at the stand your ground hearing, is there a reasonable probability with the addition of that additional details, could the jury have found differently and have come back and acquitted Mr. Lahens of both cases? Our position is that, in fact, there's more than a reasonable probability that it would have made a difference. The question of whether or not Mr. Lahens reasonably believed that deadly force was necessary really comes down to what Mr. Lahens believed, and was his belief reasonable? And to argue that there's no reasonable probability that his direct testimony about what was going through his mind could have made a difference in establishing the affirmative defense of reasonable use of deadly force doesn't make a lot of sense, in view of the reasonable probability standard. With regards to the jury instruction, it's our position that really, as I stated earlier, really, while the Basallo and Brown decisions did post-date the trial for Mr. Lahens, in fact, the points of law that they discuss existed prior to those decisions. And trial counsel should have caught it and objected to the instruction, which was problematic and again imposed an additional burden, additional elements with regards to both the defenses with regards to Mr. Doralee and Mr. Rodriguez. Counsel in the Basalo and Brown decisions caught the very same issues, and so obviously it was there to be caught, and trial counsel was in effect for failing to catch it. Now, fundamental error, Basalo and Brown call these instructions fundamentally flawed. Fundamental error is not subject to harmless error review. By its very nature, fundamental error has to be considered harmful. If the error was not harmful, it would not meet our requirement for being fundamental. And I'm citing to Reed versus State, 837 South 2nd 366. That's a Florida Supreme Court case from 2002. So as this instruction is fundamentally flawed and really
Is
cuts...
it fundamentally flawed as to both counts or just the attempted second-degree murder count?
I would argue that well, it's my position that it's fundamentally flawed as to both. That wasn't candidly raised to the same effect. The primary argument is that it's most fundamentally flawed, clearly fundamentally flawed with regards to the attempted murder charge, Mr. Rodriguez, but it's our argument that the same rationale would apply to the aggravated battery charge on Mr. Doralee as well.
But you concede there was evidence of injury to Mr. Doralee.
There was evidence of injury to Mr. Doralee. With regards to Mr. Doralee, the reason that the instruction is problematic is because the amalgamated self-defense instruction makes reference to a firearm, which in this case there's no requirement of a firearm with regards to a self-defense on the aggravated battery with Mr. Doralee. So again, with regards to Mr. Doralee, while there is evidence of the injury, there's no evidence of a firearm. And the way that the instruction is worded is so confusing.
Wasn't he struck with a firearm, and wasn't that the evidence, that he struck him with the
Well, there's-
firearm, and that's how he was cut and injured?
You're correct. And I apologize, I phrased that confusingly. There was no evidence that Mr. Doralee possessed a firearm, is what I meant. And that's the way that the composite instructions can be read to require that in order to find that reasonable deadly force was appropriate for Mr. Doralee, he would have had to have had a firearm.
All right,
I think my time
counsel.
is up.
Thank you so much for your argument.
Thank you very much for your time and consideration, Your Honors.
Thank you both. All right, well, I